Angela Alsobrooks built her political career on a distinct philosophy: the justice system is where people end up when society fails to invest in them. As a prosecutor in Maryland, she focused on improving community safety through systemic reform. She championed second chances, particularly for nonviolent drug offenders. She launched programs to give people a clean record and keep them out of a cycle of continuous punishment. Today, that philosophy is deeply intertwined with Maryland's legal cannabis market. In its first year alone, adult-use retail sales in the state surpassed $1.1 billion. This chart illustrates exactly where the state's 12% sales tax goes. Notice the largest slice here. 35% of all that revenue is funneled directly into the Community Reinvestment and Repair Fund, targeting local areas hit hardest by past enforcement. This local, state-run economy is the financial engine actually funding the social mobility and justice reforms Alsobrooks has advocated for her entire career. These legal cannabis protections were carefully engineered right here at the Maryland State House in Annapolis. State lawmakers deliberately built a legal firewall to protect their local market from federal interference. Now serving in the U.S. Senate, Alsobrooks is actively pushing a piece of federal legislation that contains the exact legal mechanism needed to dismantle her home state's industry. She is a co-sponsor of Senate Bill 4879, formerly titled the Let Doctors Provide Reproductive Healthcare Act. While written to secure healthcare access, the text establishes a structural precedent for federal intervention. The framework protecting medical services is the same one needed to dismantle state-level drug reforms. The entire multi-billion-dollar legal cannabis industry only survives because individual states wield absolute authority over their own borders. They use the 10th and 11th Amendments of the U.S. Constitution as a physical shield against federal intervention. States like Maryland pass specific shield laws that legally forbid local police departments from cooperating with federal agents to enforce national drug bans. At the same time, the 11th Amendment prevents states from being dragged into federal court by private entities. This protection is the only reason Maryland can run its own local licensing boards and legally ban massive out-of-state corporations from importing cheap cannabis. Total, unyielding control over the state border is the only thing keeping the local craft cannabis market alive. To guarantee the free flow of reproductive services, the authors of Senate Bill 4879 had to find a way to break through those exact state protections. Section 3 of the bill explicitly abrogates state immunity. This removes the ability for a state to cite the 10th or 11th Amendment as a defense when faced with federal lawsuits over cross-border services. The bill goes a step further by establishing a private right of action. This grants private individuals, corporate entities, and the U.S. Attorney General the direct authority to sue a non-compliant state government in federal court. Validating the idea that federal power can override local laws to manage interstate activity transforms a piece of healthcare legislation into a federal battering ram for state-level dissent. Political power is entirely content agnostic. Once this legal mechanism is validated on the books, a future unified Congress can pick up the exact same framework and apply it to any local policy they dislike. The overturning of Roe v. Wade sent control over deep moral issues back to the states, triggering a rush of competing, aggressive local laws. Politicians on both sides of the aisle play a long game of centralization. Whenever a partisan coalition secures federal majorities, the concept of states' rights is routinely abandoned in favor of sweeping national mandates. Imagine a future administration passing a Drug Enforcement Supremacy Act built entirely on the legal blueprint of Senate Bill 4879. It would legally bypass the 10th and 11th Amendments to force local police to crack down on state-licensed dispensaries. Building a powerful legal weapon to secure one specific freedom ensures that same weapon is sitting on the shelf, fully assembled, waiting for the opposition to use it against a different set of local liberties. This chart projects the financial reality of that exact federal override. The combined legal markets of Massachusetts and New York alone represent over $2.7 billion in active annual economic activity. If massive out-of-state corporations use the Senate Bill 4879 template to sue state licensing boards, or if federal agents force a shutdown, all of this local tax revenue instantly drops to zero. the human cost follows immediately. Millions of regular citizens, workers, and local business owners who have operated entirely legally under state rules would wake up exposed to sudden federal criminal charges and asset forfeiture. This creates a direct collision with the goals of politicians like Angela Alsobrooks, whose career has been focused on keeping nonviolent drug offenders out of the criminal justice system. Every time lawmakers centralize power in Washington to bypass local legislatures, the mechanics of that overreach eventually trickle down to punish individual citizens. It forces voters to ask a difficult question. Does protecting access to one critical service justify writing the exact legal framework needed to dismantle the social and economic foundations of your own state?